So Sarah, start by asking if you could tell us a little bit about yourself and about your practice as well.
Sure. Yeah, so I'm a barrister in the UK, was called in 1994, and then took silk in 2017, which means became a QC. I also sit as a recorder, which is a part-time judge, which we can do in the UK and combine that with day-to-day practice. And I sit in the civil and criminal courts as well. So my day-to-day practice these days is mainly financial disciplinary work. So financial services, FCA cases, disciplinary matters relating to finance of one sort or another, and a bit of financial crime, insider dealing or investment fraud, misleading the market, that kind of thing. In addition to that, I'm quite lucky because I also get to do weird and varied things like police discipline and occasionally doctors, barristers sometimes, and inquests. Usually Article 2 inquests that involve juries. And so I've got a pretty varied practice and I've been very lucky. In the old days, I started out thinking I wanted to be a criminal practitioner doing murders and serious crime. And I did that for about 10 years and then ended up sort of specialising in the areas that I do now. But the great thing about that was that it gave me 10 years of doing back-to-back jury trials, which has been invaluable in the practice that I've ended up going into. So that's a bit about me.
You are now at Sergeant's Inn, I understand. What caused you to join that set?
So mainly because they are probably the preeminent regulatory disciplinary set in the UK. They don't pay me for saying that, by the way, but that's the reason why I joined them, because I wanted to be in a set that did a range of regulatory disciplinary work so that I could branch out a little bit from the financial side, which I enjoyed and I think I'm relatively successful at. But I just felt that I had it in me for one more big challenge before I got too old. And so I wanted to do a slightly broader range of work. And my chambers is the leading set in particular for healthcare and police law. And that fitted in, it seemed to me, well with the practice that I already had, whereas they wanted to branch out and start doing more financial work. So it seemed like a natural fit. And I've been there since 2011.
Would you say a large part of your practice involves trial work as opposed to regular hearing?
So certainly in the past, yes. Nowadays, particularly since I got silk, I tend to do bigger cases less often. And so I could easily be instructed in a case that may take 2 or 3 years to prepare and actually come to trial. And then the trials might last anything from, say, 2 weeks up to 3 months. And so what I tend to do is probably 1 jury trial a year, let's say, but a reasonably substantial one. And then, for example, maybe 1 or 2 inquests, and then maybe 2 or 3 smaller disciplinary cases, and then in and around that, applications and other hearings.
Sarah, would you say that you've always wanted to be a trial lawyer?
Well, actually, I always wanted to be an archaeologist. Weirdly enough, and that was what I was always for some reason always interested in. And on Wednesday afternoons at school, when we used to have to go and do activities outside of lessons or sport, I used to go down the road to an archaeological dig and sit in a muddy trench with a toothbrush, brushing away from a, medieval dog's jawbone or something. And I thought this is what I wanted to do. And then I told my tutor at school that I was going to read archaeology at university. And he just looked at me quizzically and said, well, why would you want to do that? It's not going to get you anywhere in life. And I sort of thought about it and I thought, well, yeah, I suppose unless I want to be an archaeologist forever, it probably won't. So I said, okay, well, what do you think I should do? And he said, well, have you thought about doing law? Because you're quite good at arguing. And he said, and if you've got a law degree, you can do whatever you want. And so I came away from that meeting thinking, okay, well, if I read law, I can still be an archaeologist. And so I went to read law. And then once you start reading law in the UK, certainly at that time, you kind of end up being a lawyer, whether you wanted to be originally or not. And so over time, I realized that actually I'd probably be a better lawyer than an archaeologist.
Right. Okay. So, did you have a mentor when you started at the bar?
Yes, I did. Tim Dutton QC, who started the Keble course, and he is one of the most, I mean, he's probably the preeminent advocate of his day and a really inspirational, kind, decent man in every sense. And I met him first when I was a participant on the course in 1999. So I'd been called for about 5 years and was just blown away by how incredible this course was and how much it really just gave me the chance to look really critically at the way I was developing as an advocate and what I wanted to do with the rest of my career. And as a result of that, I wrote to him and I said, you know, I was so impressed with the course, and is there anything that I could do to help or contribute at all? And he was very kind and said, well, you know, come back and be a helper. And so I did that. And then after a few years, he said, look, I really need some help with running the criminal side of the course. So would you like to do that? So I did that. And then a few years after that, I became an advocacy trainer. And then it slowly developed, I guess, as an advocate. And all the way through that, he just provided a huge amount of support, belief in me, and just confidence, I suppose. And I learned so much from him about how to be not just a good advocate, but also a good ethical professional, and also how important it was to actually remember that you need to give this away. You need to give it back to the profession in order for the profession to become better at what it does and therefore perpetuate what we do, and also, of course, to make it just that bit easier for the next generation. And I learned all of that from him. He was and is the most incredible man.
Did you have a chance to work on a particular trial with Mr. Dutton?
No, I never did, and it's a great regret of mine, actually. His and my practices at that time were very, very different, and he was obviously much more senior than me. And so I've never done a case with, actually, that's not quite true. I've never done a case where I've actually been paid. I did do a pro bono case with him, I've just remembered, where I was asked to represent a lady who had had a very, very unpleasant experience in her pupillage and had been treated very, very badly by the institution that she was doing pupillage with. And to cut a long story short, they had basically fired her and refused to sign her practicing certificate, which pretty much ended her career. And I was asked to advise her for particular reasons by my Inn of Court, which I did. And I identified that she had a route of appeal. And so the initial route was in writing, and so I drafted a skeleton argument and we submitted that. And the Bar Standards Board, as it then was, fudged it, I'm afraid, and came to a very, very poor decision and really left her in no better position. And so I looked at the rules again and worked out that she had yet another route of appeal, but this time we were allowed to ask for an oral hearing. And I said to her that I thought what I needed to do was to get her a senior silk to lead me, because I realised that part of the issue was that she didn't have a name representing her that the people who are making the decision would know and necessarily respect. And so I asked him whether he'd be prepared to represent her pro bono with me. And because of the kind of person he is, he said yes. And so the two of us then represented her successfully on her appeal. And he was phenomenal in that, and gave up his time completely pro bono. And I remember going to a conference with her, with Tim, where she met him for the first time. And he said to her, you have suffered the most grave professional injustice. And on behalf of the profession, I am so sorry for what's been done to you. And we're going to put it right. And I just thought, what an incredible way to start a conference. And I've remembered that and have used it myself since. So yeah, it really was an incredible experience.
And I think Mr. Dutton was the chairman of the bar at one point.
Yes, he was. In fact, I think he just finished being the chairman of the bar when we did that case together, which was one of the reasons why I thought he would be an obvious choice to do this case. But, you know, this is a man who had very little time and certainly had no need to give up his time for somebody who, frankly, was in a very vulnerable position and could never have paid him back. And, you know, it's the mark of the man that he did it and did it so willingly. And I learned a lot from that as well, that, you know, it's my duty to help people, to stand in front of people sometimes when they really need it, even if they can't pay you. You know, you just have to be prepared to step up, because that's the gift that we've been given in this job, is that sometimes, not often, but sometimes you really can change people's lives just by giving them a helping hand when they need it.
That sometimes is the most valuable takeaway from a lot of things, isn't it?
Yeah, I think so. I think it's easy to forget that that's, you know, what we should be aiming to do. But when you get caught up in the sort of commercial aspect of what we do, and we are, after all, a business, you know, we can't do every case pro bono. But one, I think, should always recognise that it's a great privilege to be in the position that we're in, and we're very, very lucky. And that there are a lot of people, even, you know, people who have got jobs and who work hard and you know, but they find themselves in horrendous legal situations that often are not their own making, and simply can't afford proper representation. And I just think it's important to be prepared to step up when called upon.
That is amazing.
No, that's quite correct. Pretty inspiring, Sarah. I remember I listened to a podcast of yours. It wasn't this year; it was perhaps last year, where I think you spoke about advocacy in general, and I was pretty impacted by that. If I recall correctly, I remember you mentioned that cross-examination was perhaps your favorite form of advocacy. Or at least one of your most favorite forms of advocacy. What about cross-examination do you like?
Well, funnily enough, and I do remember saying that, I remember being asked that question. It's called the Advocacy Podcast. I guess the clue's in the name. And I remember saying, and I'll tell the same story now, that when I first started in the job, we had no training. There was no formal training, and really no informal training either. And the keyboard course that I went on 5 years into practice was entirely voluntary. And before that, I'd had 5 excruciating years of being, you know, ritually humiliated day in, day out in the courts, mainly the lower criminal courts, which is where I practiced at the time. And I had no idea how to cross-examine witnesses, and nobody had told me the difference between an open question and a closed question, and why it's a good idea to ask closed questions in cross-examination, and the horrendous things that can happen to you if you don't. And I used to wonder why virtually every cross-examination I did was, I felt, a car crash. And so I went away and I read a few books. I thought there must be an answer to this. And I read some books, found some advocacy books, and I read them. And they were, at that time, great books about, you know, great advocates doing amazing things in trials. But what they didn't really do is say, look, here are the basics. You, completely clueless barrister with no training, these are the absolute basic nuts and bolts that you need to know about basic cross-examination. And so it was a lot of trial and error, and eventually I realised that the key to it all was A, preparation, excruciating preparation, and B, closed questions. And once I'd realised both of those things, then I started to be a little bit more effective as a cross-examiner, and then I started to enjoy it. And so that's why now I would say that cross-examination is the thing I enjoy the most, but only if I have done both of those things. So prepared it to the nth degree, and most of the time ask only closed questions. So, yeah.
Sure. You mentioned preparation, Sarah. How do you prepare for a cross-examination?
So, I mean, it takes a lot of painstaking hours. So, for example, a day of cross-examination could easily take a week in preparation. And what I will do usually is I will have my own separate note. I would never, ever cross-examine a witness just based on a witness statement, ever. Because invariably witness statements are written by people who don't do cross-examination, or examination in chief for that matter. And so they're not written in a way that is actually very user-friendly. And so what I will do is I will take the witness statement of the interview, whatever it is, and the documents, and then I will start with what are the basic premises that I want to get this person to agree to before I then get into the detail of the case. So, for example, cross-examining an alleged insider dealer, you know, I want them to accept that insider dealing is cheating. that they know what inside information is, that they would have known that at the time, that sort of thing, these sort of headline premises, so that they would have to agree to. And then I would draft them out first of all. And all of this I would go back and constantly refine it. But once I've got that, then I will generally work on a chronological basis, because I think generally chronological is the easiest way for an audience to follow what you're doing. And I don't necessarily buy into the suggestion that what you're there to do as a cross-examiner is confuse the witness by jumping around all over the place so that they never quite know where you're coming from. I actually think that makes the audience feel a bit sorry for the witness. And so I would generally at least start the preparation chronologically from beginning to end, and work my way through the various documents and issues that I need to deal with. And I will normally put a signpost, so a headline topic, and then draft out the closed questions on that topic. And then often what I will do is in square brackets, I will put what I'm expecting the answer to be. And then often when I do that, I will think to myself, do you know what? That's the wrong question. Because if I ask that question, I may well not get that answer. I may get a different answer. And so then I need to change the question. Or sometimes I'll realize that actually I need to ask 3 questions in order to get to that one question where I want them to give that answer. And so the mental discipline of actually drafting that out, literally verbatim in advance, forces me to think through the implications of every single question. And so then when I've done all of that, I then go back over it with a fine-tooth comb. I'll cut out, half the questions I've asked. I'll refine it a bit more. And then I put in absolutely every page reference and every exhibit reference and everything highlighted in yellow. I have very strict color coding. I'm a bit OCD like that. And so this is what I've just worked out over the years, so that I know that I've got absolutely every exhibit, every page reference, and then within the exhibit, sometimes I will actually put, paragraph 3, and then I'll go to the exhibit and highlight paragraph 3, so that I never get lost. And I'm always one step ahead of the witness. That's the other thing. You've always got to be one step ahead of these people, particularly if you're cross-examining, commercial clients or witnesses who are often very intelligent and very well prepared. You've got to be one step ahead of them. So that's how I do it.
Sure.
It takes a long time.
Sarah, I remember when I did my first trial, my only experience of cross-examining a witness is by watching my own senior partners cross-examine. I wasn't an advocacy trainer. The advocacy training program was not available at that time. So I learned from watching my seniors. Now, I remember when I first started, I'd actually write the questions down. I wasn't a slave to the script because I realized that you can't be. But I used to actually pick issues and draft the questions. Yeah. And then as I got a little bit more senior and I started doing more trial work and with a lot more experience, I realized that you can't. It's not really advisable to do that. And perhaps like what you just said, pick out the issues and look at the smaller issues and evidence in that issue. Now, how would you say for someone who's in their first or second year going into doing their first trial, how do they transition from a script to, someone more experienced like you, where you can just pick the issue and then deal with the issues? How do they transition smoothly? Because it's not easy.
No, it's really not easy, but nothing about good advocacy is easy, I'm afraid. There's no shortcuts. And the other thing I would say is that there's no one size fits all. So everybody in the end has got to find their personal brand and what works best for them. And so what I'm describing is what, by a lot of painful trial and error, I've come to realize works best for me. But what I always say to younger advocates, particularly when I'm advocacy training, is write it all out to start with, so that you've gone through the mental discipline that I've just described. And then by that stage, by the time you get to the end of that, you've got a clear route map of the targets you need to hit, the order you're going to hit them in, and how you're going to do it. And you also know where everything is in the documents, and you know what all the issues are. And the confidence that that gives you when you go to court and you know that you are absolutely on top of it, whereas probably no one else in the room is on top of it in the way that you are, means that even if you don't follow the script slavishly, you know it's there. And so if there's something happens, something becomes slightly disjointed, you get an answer you're not expecting, you've always got the confidence of knowing that you've got the next question there if you need it. And I don't, personally, I usually do end up following my script. But I suspect that most people who watch me don't realise that I'm doing that, because I know the script so well, I don't have to keep looking at it. I know what my next point's going to be. And so I can look at the witness and I can judge how the witness is responding. And I can look at things like body language and eye contact and say, oh, well, they're not enjoying that, you know, or, oh, he's just said something, or she's just said something interesting. Let's explore that. And it just gives me the confidence and the freedom to be able to do that. And so what I would say to a junior advocate is write it all out and do the preparation. And then over a period of the years thereafter, you'll find your own level as to how much you've used the script that you've prepared. But if you never actually get into the habit of the mental discipline of doing that level of preparation, then frankly, you're never going to reach the top of the tree in terms of advocacy. You know, in the old days, people used to say, oh, you can't teach advocacy. You're either a brilliant advocate, you know, you're either Cicero or you're not. That was very much the case when I started. And I would do like you. I would look at my pupil supervisor and just think, well, yeah, OK, that's great. He's just shown me how he does a really good cross-examination. But he was incapable of explaining to me how I should do it. And that wasn't because he wasn't a good teacher. It was because he'd never been taught and he didn't really know how he did what he did. So I've had to deconstruct for myself how to do the job and how to make it work for me. And, you know, I think that the point is, what I've got to is that the preparation and the mental discipline of doing that level of preparation is absolutely fundamental to any good advocacy, not just cross-examination. And any really good bit of advocacy that you'll see in court given by anyone, junior or senior, will only ever be as good as the amount of preparation that's gone into it. Yeah. And there's no substitute for that, I'm afraid. There really isn't. I wish there was, but there isn't. If you don't do the work, you're never going to be top of the advocacy tree.
Absolutely.
Sarah, did it take a while for you to conduct your own first trial when you first started out? Because I think what I find many lawyers in our neck of the woods, that what they face is that it takes them perhaps until their third or fourth year to be able to conduct their first trial. Was that the same experience for you?
Well, not really, because I was doing general crime for about the first 10 years. It meant that I started off doing really small criminal stuff in the magistrates' court. So, you know, shopliftings and minor drugs cases and burglaries and things like that. And so I did do trials from a very early stage, but they were pretty minor. But I mean, that was a real baptism of fire, because in those days you'd have these very stern lay magistrates who had been doing the job for 20 years, and they used to consider it sport to have a pop at the new pupil who was turning up to do a shoplifting, and really would give you a very, very hard time. And then if you're, as clueless as I was, you tend not always to do a particularly good job, which then plays right into the hands of certain types of lay magistrate in those days. But, when I look back on it, what doesn't beat you makes you stronger, I suppose. I wouldn't want to go back to that, but it did make me, I think it made me wake up and realize that I needed to actually work out how to do this job more effectively than I was doing it when I started.
Sure. If I could just bring us back to cross-examination and the preparation for a cross-examination. You mentioned that it's pretty important to read the documents. Do you think that it's important to read every single document in a brief before you start a cross-examination?
Well, I would, absolutely, I would. I never want to have not read everything.
Yeah.
Sometimes, I mean, it really depends. A lot of the financial cases I do, by the time you get to trial, the financial issues are not generally in dispute. So if insider dealing, for example, the fact that the chap or the lady has traded 5 times in 5 different stocks and the profits made, that kind of stuff is not going to be in dispute usually. What the inside information was generally isn't in dispute. The fact that it's inside information isn't in dispute. And so you know, I don't have to spend hours plowing through trading records because those are not issues that anyone's going to query. So you can be a little bit selective up to a point, but any document that is even quasi-relevant and likely to be a document that, for example, I want the jury or the panel to look at, or the judge, then yes, definitely. I would hate to go into court and not having read something that might be important. And of course, in the end, as you know, even these big cases usually come down to a handful of key documents. But the trick is to work out what those handful are. And I always think it's a bit like, you know, when someone throws a deck of cards up into the air and then says, you know, find the ace of clubs, and you have to go through all the cards to find the ace of clubs. And I always think it's a bit like that with the preparation for advocacy, that, you know, you've got all these documents that have been sort of thrown up into the air in not necessarily a particularly intuitive order, and you've got to go through and find the ones that actually matter. But you're only going to find them if you've done all the preparation and actually looked at all the cards.
Sure.
Yeah.
Sarah, how would you handle an unexpected or an unanticipated answer from a witness?
So I remember someone telling me a story about an advocate whose name I can't remember, who was, again, in a long distant past, one of the great advocates of the day, and being told that whenever he got an answer he wasn't expecting, his response would always be, I dare say, and a sort of wave of the hand. So, you know, yes, I saw your client cut the victim's head off with a machete, and then I saw him standing there holding the bloodied knife while the head, you know, rolled down the road, to which he would go, I dare say, and would just move on. And I didn't take from that I should adopt that myself, and I haven't. But what I did take from that is that you must never betray that you've been wrong-footed, even if you have. Because even if you give that away subtly, or maybe not so subtly, what you're doing is giving away the balance of power. And somebody else once described it to me as, you've got to fake it to make it. So even if you are not feeling confident, if you've got an answer you didn't want and it's a catastrophic answer, and let's face it, we've all been there, and it does happen to me even now, because sometimes you've not got a very good case and you play it as well as you can, but you're never going to deliver the knockout blows. And, you know, bad answers happen. And if you let it show, then what you're doing is that you're signaling to everyone in court that it's a big deal and that you're adversely affected by it. And so I've sort of practiced how to fake it to make it. And it really is as simple as, you know, the body language. So I always make sure I stand 4 square to the lectern. And if I'm going to lean on anything, I will put both hands so that I do it in a square, sort of upright way. I'm not sort of leaning with one leg behind the other and sort of bending over so that I look like I'm diminished. I'm not very tall as well, so, you know, I need all the height that I can get. And I always look at the witnesses when I'm asking them the questions. And when they're answering, I will just, you know, I will stand and I will look them in the eye. And then I'll pause, I'll look down, and then maybe ask the next question. But what I will not do is betray if they've given me an answer that I didn't want. And what I also realized is that trials are very rarely won or lost on the basis of one wrong question or one wrong answer. And not necessarily will people even necessarily notice it's happened unless you go to pieces and make a really big deal out of it. So that's part of what I try to teach in advocacy training is, you know, even if something's gone wrong, it may not matter unless you let everybody know that it's a problem. And so I teach people the sort of techniques, the physical techniques that I've learned to not give that away.
So one of the more important rules of cross-examination that I've learned is that you only ask questions you know the answers to. Do you think that there are any exceptions to that rule?
Yeah, there can be, and I always say to people that they should not ask a question to which they cannot reasonably predict the answer. Certainly in the early years, because sometimes you do have to ask questions where you don't know for sure what the answer is going to be, but you can, if you think about it and you've planned it out the way that I described, you can say to yourself, if I ask that question, what do I reasonably think the witness is likely to say? And provided the answer they're going to give is either helpful or not harmful, then it's okay, in my view. Sometimes you do have to ask a question you don't know the answer to. I'm actually struggling to think of an example. It's so rare. I think it's very rare that you're in a position where you genuinely have no option but to ask a question that you don't know the answer to. Because if it's on an important issue, you should have some idea what the answer is going to be. And if you've plotted out the questions so that it's 1 point per question and it's incremental, then you should be able to predict what the answers are.
Have you ever been before a judge, or at least conducted a trial before a judge, who just kept interrupting your cross-examination?
Oh yeah, all the time. Yeah. It doesn't happen so much now, but it used to happen a lot when I was younger for the reasons I've said. But yes, of course it does happen, and it still can throw you off. It still throws me off from time to time. And sometimes if you're in a weaker moment, you think to yourself, oh, is it because I'm not any good? You know, am I not doing this properly? Is it not what he or she wants to hear? And if you're really honest with yourself, sometimes you have to say, yes, actually, I'm not doing this very well. I haven't done the preparation that I should have done. And I'm not necessarily pitching this in the way that this judge wants. And in the end, you have to think, who is my target audience? So if my target audience is the judge or a panel in a tribunal, and they're making it clear to me, whether politely or otherwise, that I'm not actually delivering what they want, I've got to be sensitive to that and put my ego out of it and say, right, I need to now adapt my approach because they think I'm taking too long on this point. And so I need to ask about something else or cut half my questions with a red pen, and be sensitive to what the actual target audience wants. Sometimes, of course, it is an important point that you do have to develop. And then I have to politely say, well, you know, I will take this as shortly as I can, but there are a few questions I do need to ask. And then usually a judge will, if they will get the hint and give you a certain amount of latitude. So it can be really difficult. And the more senior you get, generally, I think the more latitude you get. I notice that I get a lot more latitude now that I'm in silk than I did when I was a junior. And certainly more than when I was a baby junior, where perhaps you don't necessarily have the trust of the court. The other thing is, it's slightly complicated. I don't know, I can't remember whether you have juries in Malaysia. I think not.
Not anymore.
Not anymore, right. Well, of course, we have juries here in jury trials. And so that can be difficult because actually the judge is not your target audience.
Yeah.
The jury are your target audience. And so you have to manage not putting the judge offside, but at the same time thinking to yourself, actually, you're not the one that I need to impress here. It's the jury that I need to take with me. And that can be a more interesting dynamic, but maybe a conversation for another day.
Yeah, I don't think anyone, maybe not even Ken, but correct me if I'm wrong, Ken, on this call has ever done a trial before a jury, because jury trials ended in 1993.
Right.
I think 3/4 of the crowd here were not even born in 1993. So.
Yeah.
Yeah.
So we were speaking. Sorry, go ahead, Janice. Sorry.
No, Sarah, at the very beginning, you used the term open questions and closed questions. And I know when I do advocacy training, it's always one of the things that you advise the students when they are cross-examining to ask closed questions to ring-fence your witness. How would you explain that to the lawyers listening to you today when you say, look, don't ask open questions, ask closed?
So, I mean,
someone who's not done a trial and may not really know what that means,
Sure, yeah, absolutely. And I didn't know what it meant either when I first started. So the simplest example of a closed question, or an open question versus a closed question, is an open question is, what colour was the car? Because that asks the witness for information, and it's totally up to the witness how the witness answers the question. A closed question would be, the car was red, wasn't it? Because you want to close the witness down to a particular answer. Yes, it was. But yes, the car was red. And so that's the most simple example of an open or a closed question. If ever you're asking a question that is allowing the witness to give you information in a way that suits them, then it's going to be an open question. Any question that starts with who, what, when, how, where, why, describe, generally will be an open question because it requires information. And you want to avoid asking questions that require information when you are cross-examining, because the important thing about cross-examination is control. And that's the best way to get control, is to hem the witness in with questions that require only short answers.
So lead in cross-examination is another.
Yes, it's another way of leading questions, and closed questions are the same thing.
Yeah. Sorry, Greg, I interrupted you.
No worries. I was just going to say that before we began, we were speaking about online trials. Do you think that there are any advantages to the conduct of a trial online?
I mean, I think in some ways they are, it's easier to just do it from your study or your office or whatever. And, if it's a directions hearing or an hour-long hearing, to have to go off to court, hang around for a 10-minute hearing or something like that, and then get back again is always going to take half a day out of your life. Whereas if it's a 10-minute hearing that you can do on Zoom, then it takes 10 minutes. So it's obvious that it makes sense from a sort of ease perspective. I think before we started the session, I was talking about actually doing an 8-day substantive hearing online, which involved 4.5 days of really difficult technical cross-examination and really complicated legal submission, and a case which had thousands of documents. It was a big financial case that should have been being heard in Dubai. And trying to manage all of that by way of an online hearing where my instructing solicitors were in Dubai. My junior was in the UK, but not in the same place as me. I think he was in Hertfordshire or somewhere. I was in London, and the only way that my team could communicate with me whilst I was on my feet, inverted commas, was by WhatsApp. And so I would get WhatsApp messages coming across the top of my screen while I'm trying to sort of cross-examine a witness. And all of that I found really, really stressful and really hard work, and trying to manage it all. And things like managing that volume of documentation. You want to show the witness a document. Well, how are you actually going to do that? What we did was we had a paralegal whose job it was to bring up the documents on the screen. And she was superb at that, really superb. We couldn't have done it without her. But of course, it meant that I had to make sure I'd given her a list of the documents that I wanted so that she had them all to hand. Things like the cross-examination, I could only see the head of the person I was cross-examining in the sort of large postage stamp size at the top of the screen. And the panel members, the 3 panel members, were similarly sized on another bit of the screen. And it meant that I couldn't take in how the panel members were reacting to the cross-examination, because all I could really see was the person I was looking at, who I was questioning. And it meant that I was unable to read the mood of the courtroom, and I found that really difficult and really stressful, and really, frankly, unenjoyable. And we got through it, and it meant that, a hearing that would otherwise have had to be put off for 1.5 years went to schedule. I would say the result was no different than if we'd all been there in person, and probably it was good enough. But in terms of my own performance as an advocate, I think it definitely suffered. I don't think that I was nearly as effective as I'd like to think I would have been in real life. I was okay, it was good enough, but it wasn't as good as I would have wanted it to be. And I do think that a lot of that was to do with the fact that it was being done on video. So if I were you, I wouldn't necessarily stick my hand up to volunteer to do an 8-day trial on video. But if it's a choice between that and putting the case off for 18 months, and it's just not in the interest of justice to do that, then sometimes you just have to get on with it. And that was one of those situations.
Yeah, it's certainly not ideal doing it online. Yeah.
No, it really isn't. But needs must. And it was right to proceed with the case and not put it off for 18 months for lots of reasons. And that's how long it would have been. If we hadn't gone ahead the way we did, it would have been, well, I mean, even now, I'm not sure that we could have got everybody involved in the same geographical place to actually do the case, because people were literally all over the world who were involved in this case. So, yeah.
Did you find that you were applying any techniques for that online trial that you think are unique to the conduct of an online trial as opposed to a physical one?
I mean, the thing is that an online trial takes away your ability to read the soft signs, so soft body language signs. And as I say, the mood of the courtroom. In real life, you can see the witness in the witness box, but out of your eye, you can see the panel members. You can see what your opponent's doing, and you can sort of take in what's going on and how it's all feeling and how it's coming across. You really can't do any of that on online hearings, and so you can't rely on any of those things. But the basic things you can do. So, for example, I think it's quite important when you're cross-examining a witness online to be relatively still and to look at them so that you are actually looking them in the eye down the camera, and not looking all over the place and looking down at a note and then looking up over here because you've got your documents on a screen that's up here. So that all has to be managed, and that can be quite difficult. And so what I would do is I would prepare my cross-examination the way I've told you I do, and then I printed it off and then would have it on the keyboard in front of me so that I could look down imperceptibly at the note and work out what my next question was going to be, and then still look as if I was looking at the witness. And that meant that I wasn't looking over here and looking down. And then when the document came up on the screen that we were showing the witness and the panel, it would come on half the screen. So again, I could be looking at the document, but as far as the witness was concerned, I was looking at them. And so it meant, at least imperceptibly, it looked as if I was in complete control and always focused on them. And I think that, in terms of the balance of power, little things like that can be really important. And you really notice it if somebody's not looking at you on Zoom. If I'm looking up here because that's where the document is, you can immediately see that that's what I'm doing. And my attention's been taken away from you. And it makes me look as if I'm not owning the situation. So that's the little things that I did that helped. But as I say, it's very difficult. And when you're junior, everybody forgets a page reference or something from time to time, or you've written down an exhibit reference and it's wrong. 20 pages of notes and something's bound to go wrong. And usually your junior will sort of tug on your gown and go, it's exhibit 164. And then you go, oh yes, sorry, exhibit 164. But if you haven't got the junior sitting next to you to do that, or to write it on a post-it note, and you're relying on them sending you a WhatsApp message, which you may or may not see flashing in the corner of your screen, that can be very difficult. So the other thing I realized is that things just take longer. They just do on video. And so not to worry if I just needed to take a little bit longer and actually say to the panel, my juniors just sent me a WhatsApp message, I'm going to pause to read it. And they would just say, fine. And then I'd pause and read it. And then I'd go, thank you. Now, please, let's go to exhibit 165. And I just had to stop worrying about the fact that things just take longer.
And we just have to get used to the fact that you've got one extra thing to look at now during cross-examination, which is your phone, which usually would be, switched off and put away in your bag and not something extra that you need to worry about. And that's quite a challenge.
It is a real challenge. And, people say, oh, when you're doing advocacy on Zoom, you need to have 5 screens so that you can bring everything up on separate screens. Well, yes, fine. I mean, do that if it works for you. But as I say, the problem is when you're then cross-examining a witness, you need to have that eye contact. And so having 5 screens doesn't necessarily help.
Yeah, certainly.
So it's you have to find what works best for you. But as I say, what I found was to do it like I said.
All right, Greg?
Sarah, what would you say, and this is perhaps to sum up on at my end, what would you say are the three most important characteristics to an effective cross-examination?
Preparation. And just take that as a given. I've already described to you, that it's like a swan swimming across a lake. The swan looks very elegant and the feet are doing this underneath. And it's only because the feet are doing this that the swan manages to look very elegant and majestic. So a cross-examination will only ever be as good as the preparation that's gone into it. And as I say, for me, a day's cross-examination is probably a week of preparation. So that gives you an idea. You can break it down. An hour is likely to be a day, maybe slightly less, but that's the sort of level of preparation you need to be doing. And without that, I think that a lot of cross-examinations are not going to be nearly as effective. So that's the first thing. Closed questions, absolutely fundamental. Mm-hmm. Yes, I break the rules. And I remember, funnily enough, the first time I ever did that, other than the first years when I didn't know what I was doing. So we'll put a line through those. But once I realized that closed questions, leading questions were the way to go, I remember very clearly the first time I broke that rule. And it was in a particular case where I did it deliberately and in a situation where I knew that it was safe because of the answers that I'd had before and the way in which the witness was responding. I knew that if I asked this particular question, and I think the question was, if it had been you, you wouldn't have sold this investment, would you? And he said, no, I wouldn't. Something like that. I can't remember, and I remember very specifically asking it and then afterwards thinking, oh my goodness, I've just broken my own golden rule. But for the first few years, I would say, don't ever risk it, because you're not going to have the ability, the judgment or the experience to know that it's safe to do it. And very quickly, examination that's going really quite well can just unravel if you forget the basics. So closed leading questions, so preparation, closed leading questions. And then the third thing, as I've already said, is, fake it to make it. If you are feeling like you haven't got a clue what you're doing, you've got the most hopeless case in the world, you've got a witness who is just there to make you look stupid, and a judge who clearly thinks you're absolutely hopeless. And let's face it, I've been in those positions, all of those positions collectively many times. You've got to not let it show. And that's all about, as I say, the body language, the looking the witness in the eye, the standing up straight, the sort of open but controlled posture. A lot of this stuff you can actually learn. It's amazing, but you can. I learned it by literally going onto Google and typing in performance skills on Google. And you can get these great presentations on Google, and also TED Talks are brilliant. 10 minutes or less, all sorts of speakers on absolutely any subject you can think of. And they're all speaking without notes, and they're all great in lots and lots of different ways. And it shows you how to be an effective performer, how to hold a room. And so I just literally learned this stuff and practiced it. And that's what I would recommend. So those are my 3 top tips.
Thanks so much, Sarah. That was really helpful. Jan, did you have any other questions?
Sarah, just one, because I think it's so important as a foundational issue to speak about for the young lawyers listening. Earlier, you mentioned that you had learned from your mentor a lot of things, and one was how to be an ethically sound advocate. Could you talk to us a little bit about what you meant by, I know what you meant by it, but if you could share ethics, a little bit of what you mean in cross-examination to our lawyers listening.
I think that, ultimately your reputation is everything, and it's easily lost. And when it's lost, it's very rarely regained. And the temptation when you are young and inexperienced, or not necessarily young and not necessarily inexperienced, but perhaps underprepared, to just bend the rules a bit, to perhaps not be as frank as you should be with the court, to try to bully a witness when in fact it's covering up your own lack of preparation, thought, whatever, or ability. It's a harder road to do things the right way, but we all know what the right way is. And we all know the people that don't do it that way. And some of them are very successful and they make a lot of money, but we all know who they are. And nobody ever quite trusts them or respects them, in my opinion. And so I think that ethics is about having the courage to recognize that you've got to do the work and the preparation in order to be good at the job. So you can't just turn up and wing it and expect everyone to think that you're brilliant and get a brilliant result. So you've got to have the ethics to say, I am going to stay up till 3 a.m. to do a good job on this. You know, I'm going to work all day Sunday because that is what this case requires for it to be done properly. And that is what I'm going to do, even though it's personally highly inconvenient and not what I want to do. And then secondly, to say, I do not need to win so badly that I am prepared to do it by breaking the rules or bending the rules or being less than honest or less than frank with the court or my opponent by not disclosing something that should be disclosed. Because invariably that kind of thing unravels and you get found out. And then it becomes very difficult to explain, and it takes a lot to recover your reputation when you get a reputation for behaving in that way. And so I think really ethics should be part of everything that we do. And we can be really effective, successful barristers and still adhere to the fundamental ethical principles of integrity, honesty, competence. You know, these are basic things that we are all capable of and we all should aspire to. And people that I have chosen to be mentors of mine have always been people who put that sort of thing at the forefront of everything they do. And, you know, for example, prosecuting a case, you know, if you do disclosure properly and you make proper disclosure of material that may undermine your case or assist the other sides, which is what the rule is in the UK, it gives you a feeling of confidence as a prosecutor because you know that you've done your job properly. They have got the material that they're entitled to do the best they can with their job. And if you're going to win on a fair level playing field. And that gives confidence as well. And then also, of course, inspires confidence in your tribunal. And that's fundamental too, because if the judges or your tribunal don't trust you, then you find that your life gets very difficult. And also, I suspect, find that you don't always win the cases you should, because the tribunal doesn't trust what you're saying.
Thank you for sharing that. That was very important. Thank you.
Thanks, Sarah.
Hi, Sarah. Thanks for the session. I just have a question about sometimes when you pose a question to the witness, you expect a certain answer. And if you don't get the answer, then you try to rephrase it just so you can try to get it out of them. But sometimes they don't really budge and they tend to stick to one answer that is not what you're looking for. So when do you know when to press on and when do you know when it's time to stop and move on?
Well, I mean, first of all, you need to know in your own head, how important is this point? Because sometimes the point isn't that important in the grand scheme of things. And so it's not worth the effort of trying to push for the answer you want and thereby underlining the fact that you're not getting the answer. So that's the first thing, is you need to know, is it really so important for me to get a particular answer? And often I don't think it is. Because what I think one should always ask oneself is, can I live with the answer I've got? And often you can. It's not as good as what you were hoping for, but it's good enough. And if you think, if I push this, then the chances are it's only going to get worse, because you can read that there is a reluctance and a hostility in the witness, rightly or wrongly, then what you need to say to yourself is, A, is it that important? And B, can I live with what I've got? And if the answer is, I can live with it, then I would say, forget it and move on. Because, as I said earlier, cases are rarely won or lost on one point. And then then what do you do? If you think to yourself, yes, this really is fundamental. So I need this witness to say that the car was red, and the witness is saying that the car was pink. You know, what am I going to do about that? Well, then I think it's twofold. One is, have you hit a brick wall? If you know that if you keep saying to him, come on, Miss Jones, the car was red, wasn't it? No, the car was pink. It was definitely pink. I was there. I saw it. The car was pink. If you ask the question again, is the witness likely to give you the same answer? If yes, then probably what you're better doing is leaving it, do something else, and then maybe come back to it a bit later when you've got the witness back onto perhaps safer territory. If, on the other hand, you think that they're just being plain obnoxious and you just need to stand up to them, then you can just look them in the eye and say firmly, come on, Miss Jones. Come on, Miss Jones, you've seen the picture. The car was red, wasn't it? Firmly, and look them in the eye. And you may find that they'll go, yeah, okay, all right. I thought it was pink, but actually it was red. And so it's a judgment call, and you need to always think to yourself, is it that important? Can I live with what I've got? If it is that important, shall I do it now, or shall I leave it and come back to it? If I have to do it now, is it because they are being just plain difficult? And if I just stand up to them, then they'll give me what I want. And often, actually, it is just a question of standing up to them and looking them in the eye and being very firm and direct. And, as I say, not giving away the balance of power. And then you'll find that you may get what you need. The other thing to remember, and I didn't know this when I was junior, but I know it now, is you have a lot more power by virtue of the fact that you are a lawyer in a courtroom than perhaps you realise, even if you're very junior. Because a witness, even a witness who's an expert witness or a police officer or whatever, will not have the courtroom experience that you've got, and definitely won't have the legal training. And so they will be scared to be witnesses in a courtroom, and they will be scared of you. Even if you feel like you haven't got a clue what you're doing and it's all going horribly wrong, don't forget that they will be more scared than you are. And therefore, as long as you look like you know what you're doing, even if you don't feel like you do, often you will get what you want just because of the office that you occupy. So don't ever forget that.
Thanks, Sarah.
Thanks so much, Sarah. That was great. What was your question?
Yes, thank you, Ms. Sarah, for this whole session. My question, I was just wondering, like during cross-examination sessions, we tend to ask questions and we just want a yes or no answer. And then when the witness tries to explain more, we say, save it for re-examination, your own lawyer will answer this. But I was just wondering if, in that case, they get the final say, like they get to the final say in front of the court to narrate the story that they want to narrate. Wouldn't it be better, in my mind, it would be better that we get it all out of the way and we get to set the narration that we want, so we get to hear their reasons and then we get to question them on that as well. So I was just wondering about that.
Yeah, sure. Okay. So the first thing is, if you have asked a witness the question, you have to let the witness answer. So if you've asked a closed question, the car was red, wasn't it? And you're expecting a yes or no. If the witness chooses to answer, well, yes, but actually under the street light, it looked pink for these reasons. You've asked the question, they're entitled to answer it. And so I would say it's not acceptable for you to cut the witness off after yes, but, because you don't want to hear the explanation. If you've asked the question, they're entitled to answer. And so some witnesses will do that. And in fact, when I train expert witnesses, I teach them the yes, but, no, but. Yes, the car was red, but explanation. And So that's the first thing, is if the witness wants to give the explanation, you have to let them give it, and then you have to deal with it. And that's where I go back to preparation, because if you prepare the way I've thought, the way I've suggested, you will think to yourself, if I ask this question, the car was red, wasn't it? What is the witness reasonably likely to say? And if my prediction is that they're reasonably likely to say, well, yes, I can see that now, but it didn't seem like that to me at the time, then I need to be thinking, am I okay with that? Because maybe I am okay that the car appeared pink, but he or she now accepts it was red. And it doesn't matter. But if I'm not okay with it, then it may be that I'm asking the wrong question, or I need to plan out how I'm going to ask the questions to get to that key one. So that's the first thing. And so the issue that you've described shouldn't arise in the way that I've suggested, because A, you will have anticipated it and prepared your questions accordingly, or B, the explanation doesn't really matter. If, on the other hand, they're giving really unhelpful explanations, then again, there's not really a lot you can do to cut them off. But often what will happen is that because you've prepared what you're doing and you've got your case theory, what is coming across to the audience is that you are developing a perfectly plausible narrative, and the witness is deliberately choosing to misunderstand, not cooperate, give information that is extraneous, not relevant, etc., etc. And so you have to be sensitive to the fact that just because you feel they're not doing what you want doesn't necessarily mean that they're coming off better. And then your third point about, well, when it comes to re-examination, they just get to unravel all the work that I've done. And isn't it better, therefore, that I do it in cross-examination? Well, yes, ideally. But what you need to realize about re-examination is it's much harder than you think. Because to do a re-examination, you have to obey the rules of as if it was an examination in chief. So you can't ask closed questions. It has to be open questions that require information. And that means you've got much less control over the way the witness answers. And the other thing that in re-examination is that the basic rule is don't do it. So unless you absolutely have to, don't do it, because chances are it's only going to highlight the bits that you'd rather were not highlighted. So it's only if you really have to do it to repair something that's really fundamental, or if you really want to highlight something that's really fundamental, that you would do it. And so for a re-examiner, what I'm always doing when I'm listening to the cross-examination is thinking, do I have to re-examine at all? And if I can avoid it, I won't do it. So don't assume that a re-examiner is going to get up there and just, magically wave a magic wand like Harry Potter and repair all the damage that you've done. Chances are they won't. So that's how I would deal with that scenario.
Thank you. That was very helpful.
Thanks, Sarah. Thanks, Michelle, as well, for the question. Anand, I think you've raised your hand. Did you want to pose your question?
Yeah, hi, Miss Sarah. Sorry, I have to keep my mask on here as I ask my question. But my question is not specifically on cross-examinations per se, but rather a point you raised earlier, especially about your days being a junior advocate in court. So more often than not, you don't get seriously taken by the judge and all, especially in terms of your questions, your applications and stuff like that. You tend to get dismissed or brushed off more easily, as opposed to if a senior counsel was to raise it. So in those instances, in those circumstances, how do you carry yourself? How do you conduct yourself in court, moving on in that situation?
Well, look, again, it comes back to preparation. If you're absolutely on top of it, more than anyone else in the room, then the court will realise that, and you'll feel much more confident as a result. So that means many hours and weekends of painstaking work for what could end up being a 10-minute hearing. But the confidence that you will have of going into that courtroom knowing I know this case better than anyone else here, including you, Judge, will help enormously. And then also it translates itself almost subconsciously to the court. And so if suddenly this junior advocate they've never seen before and don't really trust starts helping the judge by making it clear that they know the case backwards and that they are there to assist with what their case is about and what the key points are and where the key documents are and things like that, then you can earn the trust of the court. And then you find that life gets a lot easier. But the fundamental is preparation. It really is. There's no substitute. If you go into court and you picked up the papers 10 minutes ago and you're leafing through them as you walk in, you don't really know what it's about. You can't expect it to go well. You just can't. And judges will see that. And because you're a junior advocate, you won't necessarily have the experience to carry it off. So for a 10-minute directions hearing, I won't necessarily spend a day working on the papers. Sometimes I will, but often I won't. But that's because I've got the judgment and the experience to know which cases I do have to spend a day working on and which I can just pick up, and have a flick through an hour beforehand. But junior advocates don't necessarily know the difference. And you can't necessarily risk it because judges are going to have lower expectations and therefore a lower pain threshold than they would have perhaps with a silk. So I keep saying preparation's everything, but it really is. And particularly when you're junior, that you can't know too much about the case and about the law. And the other thing I learned as well was my pupil master once said to me when I came back to Chambers once and I was moaning because I'd spent all day Sunday working on a case and then got to court and a witness didn't turn up or whatever and it was adjourned. And I came back and I was like, I wasted my whole Sunday working on this and it was a total waste of time and I'm fed up with this job. And he said to me, legal knowledge is never wasted. And I said, well, what do you mean? And he said, well, the work that you did preparing that case that then didn't go ahead, in a couple of weeks or a month or maybe even a year, you'll get another case. And it'll be on similar legal principles or law or facts or whatever. And because you did that work on that Sunday, then it will mean that you will be ahead of the game the next time round. And so the knowledge that you've gained and the time that you've spent will never be wasted. And I've always found that to be true. So I never now begrudge putting in the work and then finding that actually I didn't need most of it when I got to court. There's always been another case where that work has been worthwhile.
Thanks, Ms. Sarah. Thank you so much.
Sarah, that's so true. It's like preparing for a case is almost as good as actually doing it. Or official, It
doesn't feel like it though, does it, when it's a Sunday and you've worked all day and it's a lovely day outside and everyone else in the world seems to be out enjoying themselves and you look back over your life and you think, for the last 26 years, how many Sundays have I done this? And probably it's most, or it's 3 o'clock in the morning and you're exhausted and you just think, I just don't want to be doing this. It doesn't feel like it's the greatest job in the world or the greatest, thing you could be doing, does it? But for me, the fear of going to court and not being completely prepared always keeps me going. And the professional pride and my ethical duty, if I take a case on for a client, they rely on me. Even the rich commercial clients who are, big alpha people, they're still in a vulnerable position, and it's me that they've come to. I wouldn't do an operation on somebody that I hadn't prepared properly for, would I? So why would I go to court and think it's okay not to have read the papers or be on top of it?
I think we should ask Ken to let us have his takeaway or your one advice.
In one word, ditto. Ditto to everything that Sarah said. Really. The most important point is, as Sarah has put it, preparation. It's everything. It's really everything. You can't develop your skills without being prepared. When you're putting it into practice, you have to have the fundamentals. You have to know what each document says before you can actually do something with it. So it's all about preparation, really. And one of the big takeaways from Sarah's talk just now was, to me, is the part about the balance of power. I've never really seen it that way, and that's really refreshing for me. It's enlightening for me.
But you use the term owning it.
Owning it and the balance of power, that's very good. That's excellent for me. That's an excellent point for me. That's it. Ditto.
Because I think, Sarah, when you talked about balance of power and owning it. A lot of cross-examination, although what you see on TV adds on to it, is a lot of there's a little bit of theatrics to it, isn't it? Yeah. How you ask the question, and like you say, how you position your hand, how you aim your body when you ask the question. A lot of it is theatrics, and when you do a trial virtually, it just all seems lost.
Yeah, it does. It does, very much so. And a lot of what we rely on to do what we do well is taken away from you. You actually feel quite sort of stripped bare in a way.
Yeah.
And it's a very different skill, I think, doing video trials, for the reasons I've said.
Yeah.
But there's a huge amount. I mean, presentation skills, just go onto Google and put presentation skills into Google. It's incredible what you can get. And just simple little things. And it's not so much, not as much about what everybody else sees when they look at you. It's also can change the way you feel about yourself. Even something as simple as standing 4 square to the lectern and just, holding the sides of the lectern for, balance and looking square on at the witness or the court. It just makes you feel more confident, as well as everyone looking at you thinking, well, there's a confident advocate. And it's not about theatrics. I don't do much theatrics. I do move my hands a bit, and you'll see me do this. In real life, I will do this reasonably often, because it was a gesture that I picked up on one of those Google searches, where it's about bringing in the audience and saying to the audience, you can trust me, because I'm opening up my vulnerable area, which obviously is the heart and the lungs. If someone was coming at you with a knife and you go like this, you've got to be powerful enough to know that they're not actually going to stab you. And it makes you look as if you are somebody who is confident and trustworthy, if you're doing what's called an open-handed gesture. But it's done, and it makes you feel confident, because you're thinking to yourself, I'm confident enough to give this impression to the court. So as I say, fake it to make it. I mean, I didn't feel any of these things when I started doing this, and just learned the hard way. But there's a lot that you can actually learn and practice that makes a big difference, and surprising difference.
Certainly. We have Adrienne, who has a question.
Good. So my question for you is, what should a lawyer do if they have absolutely botched cross-examination session? So all the answers that you want aren't in your favor. How can a lawyer save their case after that?
Well, look, I mean, the first thing is we've all been there. So, don't take it too hard. It's a rite of passage, frankly, for any junior advocate. And often you will learn most out of getting it wrong. So you have to just say that's, I'm going to chalk that one up to experience, and think to yourself, why did this happen? Just spend a bit of time deconstructing, and perhaps with someone more senior who you trust, who you feel you can have a frank conversation with, and sit down and go, look, this is what happened, and I'd just like you to help me understand what I did wrong so that I can do better next time. And never be afraid to say to yourself, you know what, I could have done that better. And in retrospect, what I did was I started off asking closed questions, and then I forgot to do that and started asking opening questions. And then suddenly the witness had got control and was giving me all this information that I didn't want. And then I didn't know how to stop him. And then it just became a sort of unstoppable, self-fulfilling prophecy. And suddenly my whole cross-examination had fallen apart. Well, when you sit down and think about it, you can probably pinpoint when it went wrong. And it will be the point at which you forgot the basics, because it was all going so well and you got so excited and so carried away, you just forgot the basics. And so you learn from it and you dust yourself off and you say, you know what, it's just a case, nobody wins them all. And I will learn from it next time. So sometimes that's all you can do. But if what you're saying is, how do I still win the case, even though I did a car crash cross-examination? Sometimes you can't, because some cases are just not winnable. We get dealt hands of cards. It's a bit like playing poker or cribbage or whatever. You get dealt a hand and you just have to play it the best you can. And some hands are unwinnable, okay? That's just how it is. And then it's just a question of losing as gracefully as you can. And other cases, you think they're winnable, and then suddenly it's all unraveling and you're going, I thought I was going to win this, and now it looks like I'm going to lose. And then it's very easy to think it's all your fault. And then sometimes it isn't. It's just that cases that appear strong, when you hear the witnesses or whatever, they just don't quite work out the way you thought. And that's just life. But other things to remember are these, that what sounds like a complete and utter car crash to you may in fact not be, because it may be that the answers the witness has given, you can still put a bit of a spin on them when it comes to submissions. So, Mrs. Jones told you that the car was pink as far as she's concerned. And obviously one, has to accept that that's her genuine recollection. However, of course, it's not that simple, because her observations have to be seen by virtue of the fact that it was dark. She was 50 meters away. There were no street lights. Do you see what I mean? And so that there are ways in which you can seek to perhaps ring fence the answers that you've got that you felt were unhelpful. And it may be that it's not a deal breaker. I mean, I've certainly seen cases won where cross-examination has been catastrophic, but clearly the judge or the jury just didn't think that it was that important. So that's the other thing. So never think that a case is won or lost just because one particular aspect hasn't gone that well. And the other thing, as I say, is don't ever give it away. If you go to pieces and you make it clear that that's what you're doing, and you know that you've really messed up, and oh my God, I'm the worst advocate in the world, and you know what that's like. You've seen advocates where they've done that, haven't you? Everyone knows what I'm talking about. You can tell when an advocate has lost it and has gone to pieces and has lost their confidence. Right. Once you give that away, then it's just going to get worse. And so you have to absolutely remember that, the head is rolling down the road with your client standing there with the bloodstained knife, and you have to remember the I dare say. Yeah, I dare say. Not suggesting you say that, but just to say it in your head, I dare say. And just, make sure that you don't ever give away that you think you've got it all wrong. And chances are it won't be as bad as you think. Honestly, it won't. Very rarely do you so catastrophically lose a case based on one not great cross-examination. It isn't like that in most cases.
Thank you. That was very insightful.
Did you have any other questions? Or?
No, I think I asked her, and through the course of this dialogue, she's pretty much talked about everything that I would have wanted to ask.
I talk far too much, I think.
No, you were amazing. Thank you for that. Yeah. Well, I'd ask this one question that I see a lot, in fact, a lot of even senior lawyers, and most definitely in the juniors when we do our advocacy training, is that when they ask a question in cross-examination and they are trying to make a point, there is this horrendous habit to say, I put it to you.
Oh, yeah. Yeah.
A put question. I mean, you can put a question without saying the put, but it becomes a habit. And we always train our students to say, don't carry out your cross-examination by just saying I put it and I put it. How would you tackle that? When
yeah,
it becomes
I agree. I mean, and I used to do this too. And part of it is, I think that junior advocates think that they need to talk like a barrister. And they have this idea that barristers talk in a particular way. And so when you go into a courtroom, instead of asking a question, you'll say, I put it to you. Or you'll say, the motor vehicle was proceeding in a westerly direction down the carriageway. The person went into the public house. And you start talking in a way that you'd never talk like that in real life. And so I always say to advocates, look, you don't have to talk in a way that you think barristers are supposed to talk. Just ask a normal question. So when you say, I put it to you that the car was red, what question are you actually asking? And the question is, well, the car was red, wasn't it? Well, is there any reason why you can't just say the car was red, wasn't it? Or the car was red. And it's about inflection in your voice. So you don't have to say, I put it to you that the car was red. You can say, the car was red. It has the same effect. And the other thing I do is I say to them, mix it up a bit. So there are lots of different ways of asking a closed question. The car was red, wasn't it? The car was red. But come on, you saw the car, it was red. You know, there are lots of different ways of asking the same question, so don't always do it the same way. So then you don't always have, I put it to you, I put it to you, I put it to you, or the car was red, wasn't it, wasn't it, wasn't it, wasn't it. So that's all to do with preparation. So when I'm looking through my notes, when I've prepared all my questions, if I've got too many questions that are statements, then I will change some of them so that it's not all the same.
Ken, I think your hand went up twice.
That's right. I raised my hand. Sarah, I was just wondering, after every session in court, particularly after a session of cross-examination, would you do a debrief session?
Yeah.
If by yourself, with yourself, if you're with the junior,
Yeah, I do actually. I always do that. And also after a case is finished. So at the point at which we've made our closing submissions and the case is actually finished, but obviously usually before the result, is I will sit down with the team and I will say, okay, now let's just look at what we've done. If we have had our time again, would we do anything differently? And what lessons have we learned or can we learn from the way we've done this case? And I found that really invaluable. And it also gives the team the chance to debrief. So sometimes members of the team are harbouring the fact that maybe one thing they didn't go so well and are blaming themselves, and it gives them the chance to actually express it and have everyone else go, oh God, I don't even remember that. Oh, did you? Really? And then they go, oh, okay, maybe it wasn't that important. And the other thing is I will actively seek feedback. And so I will come out of a cross-examination and I won't want people to say to me, oh, that was brilliant. What I actually want is for them to give me constructive criticism. And so I will say, the way I did that bit, I'm not sure that really quite worked. You know, what do you think? What was your impression listening to it? And what do you think I could have done to make it better? And then that allows people to actually tell you what they genuinely think. And sometimes, you know, they will say, well, actually, no, I thought it was fine. And actually, what you don't realise is the effect that it had on the jury or the board or the judge or whatever. Or sometimes they'll say, well, actually, yeah, I think you're right. And I think the reason is because you did this. And maybe if you'd done that, it would have been better. And then I will also say to people, look, you know, be blunt with me, because I wouldn't be asking you the question if I didn't genuinely want to know what you think. And also if I didn't respect your view enough to genuinely want to know what you think. You know, nobody's perfect, and I'm certainly not. And all I want to do is to be a little bit better in every case. And so I try to sort of give people the freedom to tell me what they think, because I'm conscious of the fact that now I'm 26 years cool and in silk. You know, people sometimes might be a bit intimidated to say, actually, Sarah, that bit of your cross-examination wasn't that great. You know, some silks wouldn't appreciate that. Whereas for me, I just think it's fundamental that I always want to be a bit better. And I've never come out of court, I don't know about you, Ken, but I've never come out of court and thought I was absolutely brilliant in every way. You know, every question I asked was flawless. My submissions were outstanding, you know, and there is nothing that I would change about that performance. It was stellar in every sense. You know, I've never come out of court thinking that, ever. You know, I have come out of court thinking, yeah, that was pretty good. But I've always been able to say, but that bit could have been better, or I wish I hadn't done that, or whatever. And so, you know, I'm just somebody that actively seeks feedback. I think it's really important to be able to do that. And also it builds trust with your team as well, in my view.
Yeah, and then by doing that, it becomes part of our process of acquiring the experience and developing our skills. It becomes part of the process, isn't it?
I agree. And it's part of the learning process as well for the more junior advocates that you're working with, who are looking at you. And I guess I have to realise now that people, perhaps younger advocates, look at me the way that I looked at senior advocates when I started out. And to me, I don't feel any older and sometimes don't feel any more experienced, but I have to recognise that that's not necessarily how people see me. And I remember when I started looking at the senior advocates, particularly the senior women, and just being terrified of them. And the idea that I would be able to say to any of them, well, actually, I didn't think that cross-examination went very well. It was just unthinkable. And also, you know, that the idea that they might sit down with me and actually deconstruct how they did what they did. It just didn't, those kind of conversations didn't really happen. But I do think they're really important because A, it's how advocates learn, and B, I think it's really important for advocates to realise, young advocates to realise that the more senior advocates haven't got to that position because we're superhuman or because we're so much cleverer than everybody else or whatever, generally not. And also that, that we're not infallible. And we have to be, you know, if we can come across as human, who sometimes do really well and sometimes not and make mistakes and are trying to learn just as much as everybody else, then it gives the next generation confidence to say, you know what, I can go into court and I can take the knocks. And occasionally a case won't go so well and I'll screw one up, or, you know, I won't do as well as I wanted to. And that's okay. Because in 26 years' time, I could still be in Silk or be Ken St. James, you know, because she's done it and she's admitted that she's been in the same position as me. And if I'd known that in my early years, if I'd known that it was okay to fail, and that failing was part of the learning experience, a necessary part of the learning experience that everybody has to go through, if I'd known that, I wouldn't have been so hard on myself in those early years. And I think being hard on ourselves is something we're really, really good at. And it's not good for our mental health, frankly. And I think, you know, we're recognizing that as a profession now much more than we ever did when I started, where, you know, you had to, I felt like I had to be completely Teflon coated and superhuman all the time. And if I ever fell short of that, then I was a failure. And people, I think now realize that, I hope, realize that that isn't, it's just not achievable, and nor is it necessary. So I think it's really important for the longevity of our profession that we are, you know, Ken, people like you and I are human, and people can have frank conversations with us where we share these things. Thanks so much, Sarah. I think we have taken up far too much of your time. Yeah, it's a pleasure. I've taken up too much of yours, I think. Not at all, not at all. I think I speak for all of us when I say that we are so grateful that you spent your time with us and for sharing all that you did with us. I certainly learned a lot, and I'm sure Jan and the others did as well. And on behalf of the firm, I'd just like to thank you so very much for the time you spent with us and for sharing your very insightful thoughts with us on cross-examination. It's an absolute pleasure, and I'm really glad you asked me to do it. I feel very flattered, actually, and honoured to be asked. Can I put in a plea for the Keble Advocacy course before I leave? It's a bit of free advertising. I now run the what's called the Southeastern Circuit Advanced International Advocacy course, which we hold every summer at Keble College in Oxford. It's a week-long advocacy course for junior members of the profession from all over the world. And we have always had a very good relationship with the Malaysia Bar. Brendan Seaver and others have come to train on the course with us, and I hope will next year. But we've also had participants from Malaysia, and we'd be absolutely delighted to continue that relationship. So if any of you are interested in coming as participants, please contact Brendan and ask for the information. And I would really love to see some of you there. You'd be really welcome, and I know that you would learn a lot and have a really great week spent living in an Oxford college for a week, which is quite a fun thing to do as well. And Ken, I hope we can get, and Janice and Greg, I hope we can get you over to Oxford for some of the period while I'm course director. But you know, our international training relationship, particularly with Malaysia, is very close to my heart, and I'm really keen that we carry that on.
Thank you, Sarah. It's really been invaluable. Sorry, Ken.
It's a pleasure.
Thank you, Sarah.
It's a pleasure. I really enjoyed doing it. Thank you for having me. Have a good evening, everybody.
Enjoy the rest of your Thursday.
Thank you very much. Okay. Bye-bye. Bye.
Bye.